The four companies that have come in the limelight as a result of this controversy are Google, Starbucks, Apple, Amazon, a whole bunch of companies that follow transactions through the internet. Briefly, what does Starbucks UK say? By the way, these are not my views, these are picked up from the UK Parliamentary Committee on Inquiry. It opened its operations in the United Kingdom in 1998. It earned over $3 billion in sales for 14 years, and it paid tax of only $8.6 million. In the last 3 years, they did not report any profit and did not pay any tax, but they informed all their shareholders that UK is an extremely profitable operation for them. As a result of the moment, they voluntarily went and said that we will pay 20 million UK pounds as taxes over the next 2 years. Going on, you look at it in the context of UK, Google earned a revenue of $18 billion from 2006 to 2011 and paid corporate tax of only $16 billion. Apple US, which is one of the most profitable companies, has cash reserves and build-up of $150 billion, of which only $40 billion are in headquarters in the United States. The rest of the $110 billion are outside the US as a result of preferential treatment that US companies get because of the check-the-box rules. It negotiated a 2% tax rate with the Irish government, and I was not able to verify whether this was with an understanding with the US government or not. What does all of this mean? It raises very important question on morality of tax avoidance. And I just would like to quote two cases, two judgments, few sentences from the judgment. One is by an English court, which is very often used in India, called the Principle of Duke of Westminster, and second is the Supreme Court decision in McDowell's case. Here is what Lord Tomlin had to say in the context of Duke of Westminster. Every man is entitled, if he can, to order his affairs so as that the tax attaching under the appropriate acts is less than it otherwise would be. If he succeeds in ordering them so as to secure this result, then however unappreciative the commissioners of inland revenue or his fellow taxpayers may be of his ingenuity, he cannot be compelled to pay an increased tax. This principle, as most of the practitioners in India know, is still being followed, still being referred to by the highest court of law in our country. This is what the apex court had to say in the context of McDowell. Tax planning may be legitimate provided it is within the framework of law. Colorable devices cannot be part of tax planning, and it is wrong to encourage or entertain the belief that it is honorable to avoid the payment of tax by resorting to dubious methods. It is the obligation of every citizen to pay the taxes honestly without resorting to subterfuges. Now, two contradictory views, obviously. As courts, they have a right to express that view. Keeping this in mind, we have structured a discussion, and we are going to have 4 modules to this discussion. I now hand it over to Jeffrey Owens to introduce the first model, for which we are going to have intervention by Mr. Parasaran, Michael Lang, and Mr. Datar. Over to you, Jeffrey.
Thank you for that introduction, and good morning, ladies and gentlemen. I seem to be spending a lot of time up on this podium, so by now you must be thoroughly fed up with me, yeah? It's just they couldn't find anybody else, I think, yes? Let me begin by saying I actually don't like the way the panel question has been formulated. Morality or legality, there's only one answer, yeah? So maybe it's the wrong way of framing the debate, but let's assume, in fact, that that's our starting point. Why, perhaps it's a good question to begin with, Ian, why are we having this debate? And from the video that we saw yesterday, you can see how the politicians are very engaged in this question of are multinationals paying their fair share of taxes? NGOs are out there lobbying, you're raising the issue. I mean, up to now, I think India's been pretty NGO-free. You don't have a tax justice network here. It'll come, so it's good to prepare for that, yeah? And also citizens have become more engaged, yes? I mean, today, You have normal families who over breakfast discuss transfer pricing, yeah? And I'm not kidding, I have 4 children, and my eldest son said, yeah, Daddy, what do you do with this transfer mispricing? Why are you helping multinationals put their money in tax havens? Yes? So normal families are taking an interest in tax. Huh? And if you look at the profile of tax, I mean, tax was generally at the back page of the Financial Times. Today, it's on the front pages. How many times has tax been on the front pages of the Financial Times over the last 14 months? 10. 10 times. Huh? I mean, I worked in tax 40 years. I've never seen that, yes?
It's every day in India, by the way.
But India is special, yes? The Indian exception, yeah? So in a sense, I mean, we've moved to a situation where international taxation, taxes that are paid or not paid by multinationals, is very much at the top of the political agenda, yes? And I think that's not a bad thing, because in some ways tax is at the center of our democracies. Huh? But what we need to make sure is that the debate, the public debate, is informed. And that's very hard, because for the NGOs, even a one-liner, Google not paying taxes, or Starbucks, not paying tax, it's easy. But then when you have to come back and explain why that is the case, you need 10, 15 pages, not just one line, yes? But I think it's up to all of us in the tax profession to try to educate people so that you can have an informed public debate on this issue. The other thing I think that has happened is that you see that the boards of companies are increasingly discussing tax issues. I mean, there was a survey done in the UK 5 years ago, and it asked how many times had the boards of the top 100 companies discussed tax. 5 years ago, it was once every 2 to 3 years. Some never. Now, keep in mind, tax is the 3rd or the 4th largest cost component of a multinational, yeah? Today, if you ask that same question, I'm pretty sure they would say at least once every 3 months, maybe even more, yeah? So in a sense, the tax directors are getting into the boards much more often. You may not like it, but I mean, that's the reality, yes? So I think things have changed. Why is this debate important from a public policy perspective? The key fact is that for any modern tax system, it can only function if taxpayers comply, or 90% of taxpayers comply for 90% of the time, yeah? You have to have voluntary compliance. You can't enforce compliances. And taxpayers will not voluntarily comply if they perceive, I emphasize the word perceive, if they perceive that high net worth individuals and multinational enterprises are not paying their fair share of tax. No? So we have an interest in this debate because unless we actually can convince the public, citizens, that everybody is paying their tax, we'll see voluntary compliance diminish, and then we won't be able to operate our tax systems. Is the debate going to go away? I mean, I talk a lot to multinationals these days, and they fall into 2 categories. There's the ostrich category that says, well, we'll just put our head in the sand and we'll keep a low profile, and a year or 2, it'll all move on. It ain't going to happen. Yeah? I think this is Pandora's box that we've opened. We need to engage in it. You need to engage in it because it's going to continue, yes? And that's why I think it's very good to have this as the topic for this discussion here, yes? Perhaps the key question, though, is, but what do we mean by fair tax? How do we decide whether a multinational is paying its fair amount of tax, yes? I mean, I may be old-fashioned, but I say, look, the key question is not whether it's fair or not, it's whether is a multinational paying the right amount of tax at the right time in the right place, huh? That's the key question to ask. But of course, you then get into the issue of, well, what do we mean by right? And frankly, that's an issue for government. Yeah? Government has to set the rules so that they feel comfortable with the outcomes from the way that multinationals apply those rules. One thing that has changed over the last 3 years is that we are moving away from a strict legality perspective on the application of tax laws to asking multinationals to comply with both the spirit and the letter of the law. No? And this is a major change that was made in OECD in 2011. The OECD has a set of guidelines for multinational enterprises. These are not the transfer pricing guidelines. These are guidelines that apply right across the field to all activities of multinationals. And when the OECD revised the guidelines in 2011, they had well, first they expanded the guidelines, the chapter on tax. Initially it was one paragraph, it's now 3 or 4 pages. And part of the agreement we had in 2011 was that governments and multinationals agreed that they must comply with the spirit and the letter of the law. Yeah? Now, I know, deciding on what the spirit is, particularly for lawyers, it's a difficult issue. You may not like it, but that's where we are today. And frankly, is it so difficult to determine what is the spirit of the law? I mean, you can look and you can ask, what was the intent of the legislators? Is there substance behind a transaction? Yeah? Would this transaction have taken place absent tax? Is it a contrived transaction? Is it just driven by tax considerations? Yes? Is the effective tax rate that you arrive at, is that in some way ethical? Yeah? Is it sustainable? Yeah? Will the CEO be able to defend it in 5 years' time? Yeah? And I think, in fact, that so there are many ways that you can actually interpret what, in practice, we mean by the spirit of the law. And in many ways, all of these questions are getting integrated into this whole question of the GAARs, yes? And that's a topic that we'll come to with Michael in a moment's time, yes? What is clear is tax planning will continue. But I think the nature of tax planning is going to change, and there'll be much more emphasis, in fact, on making sure that your tax planning is sustainable, that your tax planning does have substance behind it, yes? And in some ways, I think what I would like to see is that this debate on fair tax leads to a different type of debate between government and businesses, that you actually have a more constructive dialogue between the tax administration and business, a dialogue that's based on openness, on trust, on a willingness to disclose, where multinationals educate the tax authorities, where tax authorities educate the multinationals in terms of what government is trying to do, because that's the way you build up trust. And to get to trust, you need transparency, yes? As I said yesterday, the 3 T's, tax, trust, and transparency, they have to go together. So what are the implications of this in a sense, for multinationals? I mean, the first thing is that you should not treat this as a moral issue. I actually think it's a bottom line issue, yeah? Because if you are on the front pages of the Financial Times for not paying tax, for having 1,250 sort of subsidiaries in tax havens, that's not good for you as a company. That's going to affect your long-term profitability. Why? Because it influences the way that your customers see you. 54% of the population in the UK are no longer buying coffee from Starbucks. Yeah? 54%. Yeah? So you have that. It also influences the way your suppliers perceive you. And it influences the way that government perceives. And don't forget, a lot of companies, government is a big client, yeah? But even more important, it influences the way you employees perceive you as a company, yes? Employees, I think, don't like to work for a company which is in the headlines for not paying tax systematically, yeah? So there are good bottom line reasons why I think multinationals need to take this issue quite seriously, yes? What are some of the implications, I think, of this fair tax debate? The first is that I think the role of tax directors is going to change. You're going to have to become much more tax diplomats. You can't just be good technicians. You're going to have to be prepared to explain more what your tax strategies are, explain not just in the courts, but also in the public domain, yeah? I think also another practical implication is that I think we have to accept that tax is just not any cost. It's a different type of cost. It has a social dimension, yes? So even though it's an important cost, we have to treat it differently. A third implication, I think, is that multinationals should not treat their tax departments as profit centers. And there are, particularly US multinationals, where the tax department is actually seen as a profit center. That's the wrong starting point, yes? And linked to that, if you have bonuses of the top management in a company, where the bonus is determined on a post-tax basis, that's giving the wrong incentives, because for every dollar of tax you save, the CEO gets another dollar of revenue, yeah? All the wrong incentives. And it's no coincidence that companies that have that model have the largest tax departments, yeah? And I'm being serious. Facts. This is not fiction, it's facts, yes? So we need to move away from that, and I think the OECD should be saying it's bonuses should be determined on a pre-tax basis. That sends the right signal. Is this? Another implication is that boards need to take more interest in tax, because boards will put the effective tax rates in the broader context of how will this affect our reputation and what are the financial implications. Yes? So those are some of the broad implications, I think, that come out of this tax debate. As I said, it's not going to go away. You need to engage, and when I say you, that means all of us, in government, in the academic community, and businesses, because we need to try to make a serious effort, in fact, to have an informed debate. And if governments are not happy with the outcomes from the existing tax rules, then they need to change the rules themselves. Thank you.
Thank you, Jeffrey, for that introduction. And that sets the tone for this topic on tax and fairness. Mr. Parasaran, you have a difficult and an onerous job to defend the actions of tax administration if they take questioning the morality of the taxpayer. What has been your experiences in the Indian context, without, of course, reference to any cases?
In my view, this issue of morality has actually emerged in recent times, even though actually the concept of morality or ethics have been debated in the past, but in view of changing values and culture, and particularly due to aggressive electronic media and the print media, which have gone against, I would say, high-bracketed taxpayers, along with NGOs, this concept of morality has particularly picked up in the West, in the UK, and in the US. And that's why we have seen many of these companies, Starbucks. In fact, last week, I was told the CEO of Sainsbury had made an open challenge that leaders of the industry have to stand up and reveal their tax practices, arguing that tax is a moral issue for British companies. And so far, I think this issue has not caught up in India like what is happening in the West. But I'm sure, I think it's also going to catch up in India quite shortly. But the danger in India is, I think, it will be quite unguided. And there will be too many elements in India, including courts, PILs, etc. Already there is a criticism that the legislature has overstepped on many occasions. In fact, I would like to remind, as far as the courts are concerned, they are not concerned about morality. They are only concerned about interpreting law as it is. And only when there is an ambiguity in law, judges tend to actually tilt towards probably ethics or morality. And in fact, in one of the celebrated cases, in Gregory v. Helvering, Justice Hand had observed, anyone may so arrange his affairs that his taxes shall be as low as possible, and he is not bound to choose that pattern which will best pay the treasury. There is not even a patriotic duty to increase one's taxes. And Lord Denning, in his own characteristic way, had pointed out that I am disposed of to rather agree with the view taken by Lord Denning, where he famously remarked that tax avoidance may be lawful, but yet it is not a virtue. Therefore, I think these are all evolving concepts. Previously, I think we are only talking about actually form versus substance, aggressive tax planning, and strategic tax planning, etc. But now we are getting into these moral issues, and this will be quite significant, and it will be debated in the years to come.
Sure.
I think it's important as we go through the debate to make a distinction between not liking the outcome from applying the existing rules and seeing those as unfair, whether it's the transfer pricing rules and treaties, and looking at aggressive tax planning, because the aggressive tax planning may in fact take place whatever the rules are. Yes, so I think it's an important distinction to make, as we go through the panel. Yes,
sure.
Absolutely.
Yeah. So that brings us, Mr. Datar. You have been representing clients defending tax planning. Do you actually, as a practicing advocate in the Supreme Court, get into this issue of morality? I mean, in the sense, what if a particular taxpayer's tax planning hits to you in your heart? Do you question yourself, is this morally correct or not?
Well, when I saw this topic, morality or legality, it's as if these are contradictory terms. I can have a perfectly legal scheme. Am I still immoral? That's the question mark. And I saw a wonderful article by David Goldberg in the British Tax Review. What is morality in taxation? He says that morality in taxation is paying more taxes than you actually have to. That is the definition of morality. And I've been reading this debate about Starbucks, about Apple, and so on. And I find there's a sense of hypocrisy in the whole debate. Because when it comes to my personal taxes as a lawyer, I can take advantage of all the schemes the government offers. It's perfectly fine. But when a corporation does it, then it's something evil, something to be demonized, which I find it's not correct. Secondly, I also want to ask one question. You asked me the question, do I feel it's immoral? I say no. You talk of Starbucks, you talk of Apple, you talk of Google, and you only focus on the direct taxes they don't pay. How many of us consider what is the employment generated by this corporation? What are the indirect taxes they pay into the system? What is the wealth they create for the nation or for the international community? And what is the total tax revenue they generate, and not just focus on the direct taxes? So if you take, for example, suppose you have Starbucks in India, and they have, say, let's say 500 outlets. They're going to pay VAT, they're going to pay service tax, they're going to pay municipal taxes, they're going to pay so many taxes. And if the Indian tax system enables them to pay zero taxes, so be it. That's the point. Secondly, in all these articles I've read, we keep on talking of the morality of the taxpayer. I thought to myself, is there anything called the morality of the legislature? We keep on hammering at the individual, at the corporation. Is making a retrospective law immoral? Is repeatedly overruling your judiciary immoral? Is reneging on your promise immoral? Take, for example, Mukesh asked me about my clients. I set up a unit in the SEZ on the ground that I'll have a 10-year tax holiday. All my rents are securitized to the banks so that all the rents go to the banks over 9 years, and after 9 years, the entire building is mine, and then I make my money. 3 years down the line, you say I'll impose 18% MAT. So 2.5 months rent goes to pay the interest. What happens to the SSE? Complete turmoil. Now, can we not think of morality on the part of the legislature? Then morality on the part of the executive. Administering the laws fairly. Not making wrong demands just because you have some targets to meet, and leave the poor taxpayer to the wolves, so to speak, and he has to litigate up to the Supreme Court. So just as there is morality on the part of the taxpayer, there is morality on the part of the legislature, there is morality on the part of the executive, and I would say morality on the part of the judiciary as well, not to bring in your personal predilections in deciding cases and go strictly by the law. And Mohan just quoted Learned Hand, and one of my favorite judges, and I'll just read his quote. Nobody owes any public duty to pay more than the demands of law. Taxes are enforced exactions, not voluntary contributions. To demand more in the name of morals is mere cant. And if you ask me, in my view in this debate, there can be one and only one commandment: thou shalt not adopt a colorable device. Beyond that, there is no obligation on the part of any SSE. Thank you.
Thank you, Mr. Datar. May I now move on to the next model, which is what is the judiciary approach and the role and the attitude of the courts? And, do actually courts look into morality in reaching judgments? Mr. Pramod Kumar, you have presided over many judgments in relation to aggressive tax planning. Would you like to introduce the topic?
Thank you, Mukesh. It's a very humbling moment because in the presence of someone as eminent as Justice Kapadia, I have to speak about how judicial calls are taken on this issue. And Mr. Parasaran is there. Please forgive me for speaking out of turn on this. Now, as Mr. Parasaran has observed, and I quite agree with him, that courts are not really concerned about morality unless there's an element of ambiguity in this. And it's only when there's an ambiguity that the questions of ethical and morality are brought in. Now, the question of morality in interpretation of tax laws, it does indeed appear, may not really bother judicial officers unless, and that's a very big unless such moral principles are implicit in the scheme of legal or contractual provisions that they are required to deal with this. I'll deal with this rider a little later. But the broad principle of judicial officers being somewhat indifferent to the issues of morality could be twofold. First, judicial officers are required to be neutral, not only vis-a-vis the parties before them, but they are also required to be neutral vis-a-vis somewhat competing set of values. And these moral issues are not only with respect to the taxpayer, but as Mr. Datar, very eminent advocate, very rightly said, these are also vis-a-vis the tax administration, government, and legislature. As he pointed out, the question of retrospective legislation is one of them. But then why only this aspect? There are moral issues with regard to the taxability as a whole. It's a coercive recovery, and it's a recovery which is done by politicians and done through the administration. Politicians take this money and put it to the use as per their priorities. And administration also in turn claims credit for recovering this money, and at least in India, I'm sure Akhilesh will agree, that sometimes the facilities they get is linked to the collections they have made. So there can't be anything moral about it. Now, if you get into such vague areas, it is indeed difficult. And as unelected judges, the duty of the judicial officers is to implement the will of the legislature. And when such moral values are not reflected in the law, it is perhaps beyond the call of their duty to fill in that vacuum, even if they see it as a vacuum. Secondly, there cannot be, and there has never been, any consensus on what is morally right. And as a result, the exercise of putting in moral values would result in more uncertainty and more inconsistency. And I'm sure this is something very detrimental to the conduct of business, particularly in the modern age, large businesses, where people who come and do business with you are not really attuned to and conversant with your culture. So it increases tax certainty. But let me turn to the rider now. The rider is that in the Indian judicial system, this doctrine of substance over form is very well established. The controversy, if there is any at all, is only on the question that at what point of time you have to look at substance over form. Is it the point of time when commercial, when the tax reasons outweigh the commercial reasons, or is it the point of time when there's no commercial reason at all? On this also, last word I believe has been spoken. Honorable Justice Kapadia in his landmark judgment in Vodafone's case did say that as long as there is some commercial reason, you cannot disregard the structure. Now, taking this call that whether there is some commercial reason or not is a very difficult call. When we look at the complex commercial structure, transaction structure, we look at the complexity of the structure and the flow of things. But we also need to take into account the complexity of business situations. For example, when IPRs are parked in a particular jurisdiction, It is not only tax driven, there could be other considerations. So this call which is to be taken is as to whether there is a commercial purpose, and you don't have to take this call as per the standards which were set 50, 60 years ago. Business situations are dynamic, things are changing. The business realities today are much different than the business realities 50 years ago. So if you have that ability to take that call and you have to take that with businessmen in mind, I think that is where, if you call it a moral issue, then judges perhaps have to take the call as to what is moral and what is immoral. But that's quite limited. It's not exactly the issue of morality. And as Mr. Datar very rightly said, morality and legality, it should not be seen in contradistinction with each other. There could be something which is quite moral, immoral, and it is legal. So, but then the broader question is that was it not unrealistic and was it not unreasonable on the part of the corporations to use these tax-driven structures which put corporates over for an unfair advantage over all other taxpayers, and vis-a-vis the ordinary honest tax-paying public also, it will be ignored forever. We live in a society where taxpayers are very well aware, their awareness levels are high, and the pressures on the governments also is proportionately going up. So how long will this be taken? When you come across as an ordinary taxpayer, seeing these corporations getting into structures which appear to them, because as I said, they don't have benefit. An ordinary person doesn't have benefit of understanding the complexity of the culture of a transaction structure vis-a-vis the complexity of business requirements. When it appears to him that all these structures are completely tax-driven. All the four examples which Mukesh has taken, these are the examples where many people believe, rightly or wrongly, that transactions were done with an eye on the tax benefits flowing from this structuring rather than commercial reasons. The Starbucks, for example, I'll not go into specifics beyond giving just one small point. When you talk of the Starbucks, what you need to realize is this: you make a payment to a Dutch company without withholding taxes, and the Dutch company pays tax which is said to be low, but I mean, after all these public hearings, nobody knows what was the tax rate. It is covered by confidentiality. And then 99.8% of this is remitted to a Bermuda company. So it's not a transparent transaction. It has certain degree of opacity, and therefore there's a public outrage against these kind of transactions. Now these are the transactions where form and substance has a role to play. And these are the transactions where difficult calls about the business purposes to be taken. I'll just conclude this segment by saying that as I talk about business purpose, I'm alive to the fact that business situations are very complex today. They can't be simply saying, why do you park your IPRs in Ireland? There could be much more than tax. It is not the 2% negotiated tax, as Mukesh pointed out, but it could be a little more than protection of the IPRs itself. But then the question is that what should the judicial officers do when these complex transactions come up, and how this is taken by them? Now this is where there is some problem area. And problem area is sometimes you see the lack of ability. And when I say lack of ability, I'm talking in a different sense. I'm saying lack of that combination of legal skills and ability to visualize business. So sometimes it is that lack of vision about the understanding of the business situations, or maybe it could be simply a confidence, or some people call it sheer populism. But that's where the issues of ability or inability of judicial officers on these complex situations come up. And I would say that one has to stay away from both the extremes and take a very surgical approach to this kind of decision making, but that's something which is easier said than done. Now, when you think of how these judicial calls are to be taken, there's one more dimension. When someone has before him various answers, various options as an answer available, what does he do? Does he wear the hat of a tax mercenary who is busy generating stateless income, which doesn't get taxed anywhere, and he's comfortable with this? Or does he wear the hat of a tax policymaker who does not want to leave any taxing opportunity missed? Or a tax moralist who wants businesses to take care of the social responsibilities more than anything else? Or finally, does he wear the hat of a tax academician who can understand the inherent scheme and rationale of a tax provision on the first principles and apply the same in that perspective? I think what we have seen in the last few years, the way Honorable Justice Kapadia did it, and we saw tax academicians coming out of the tax judges. That is perhaps the role where the tax, how the calls are to be taken comes up. Now, last point I would make is that as for the media and environment, which is what Mukesh has put on the slides, I think yes, things may matter, and these things may even subdue otherwise independent and fearless judicial officers. The atmosphere of mistrust and suspicion, the atmosphere that prevails in India today is certainly less than conducive, and irresponsible media coverage could also be one of them for fearless decision making. But then what do? You have to develop your strength. I mean, as a judicial officer, I would think it is necessary that they have to remain indifferent to these things, and they also have to maintain a respectful distance from the stakeholders. They have to be a little aloof, away from the press, away from, the kind of knowing the reactions to what they do, and follow those high traditions, high judicial traditions for this. It goes a long way in ensuring that you have the strength and ability to withstand such pressures. And that's where you have somewhere like Honorable Justice Kapadia, who is like a role model, and he'll keep on inspiring generations to come, not only for his brilliant orders and those pragmatic approaches to the tax laws, but also for his highest standards of judicial conduct on the bench, off the bench, in accordance with the high traditions of judicial office. That's my take on this.
Thank you. Before I hand it over to Michael Lang as to how does GAAR fit into this debate, Mr. Parasaran, very quick comment. Mr. Pramod Kumar talked about the influence of media. Would you like to comment on the influence of political environment on this debate?
See, I personally feel neither the media nor politics should in any way influence courts' judgments. And I think judges should completely keep away from both politics and the media. And the topic for discussion is what is the attitude and the role of the courts in this debate. Are judges well placed, or should they even bring morality into reaching decisions? But as far as India is concerned, there have been, I think, varying degrees in the approach to morality. And it all depends upon the individual perception of judges. And we saw how one particular judge in McDowell actually took an extreme view, I would say. And of course, in Azadi, the court showed correctly a greater latitude. And in Vodafone, with a great amount of difficulty, the court reconciled both Azadi and McDowell. And till then, actually, there was a lot of confusion. In fact, they said that we can actually pierce through the transaction and go into the substance, was the argument of the revenue in many cases. And after Azadi, they went slow. And now after Vodafone, the concept of only look at as opposed to look through has been evolved by the Supreme Court. And as far as general principles are concerned, judges are of course swayed away by moral considerations, but that can only happen where actually the conduct of the assessee is so shocking, where, as Arvind Datar pointed out, there is a clear-cut scheme to evade tax. There is a device. Unless and until that exists, in no other circumstances, I think the judicial mind should actually innovate or find out ways and means to actually find out something was wrong, and this is opposed to actually morality or ethics, when it is otherwise actually legally permissible.
Thank you, sir. Michael, would you like to introduce the topic on how is the GAAR fitting in this debate of tax morality?
Thank you very much, Mr. Chairman. Maybe before we come to the topic of GAAR, a short general remark on the topic, and maybe taking a different approach since we've talked so much about taxes. If we talk about a completely different subject, and let's assume we are talking about speed limits, and let's assume that we have a speed limit of 90 miles per hour for the highway, at the highway, and this is the law, and then there is a public debate whether the speed limit for environmental reasons or whatever should be reduced to 70 miles per hour. Then I think there are two situations where I do not have a problem, and there are two situations where I have a problem. One situation where I don't have a problem is if the driver himself thinks, well, this is not good for the environment, therefore I don't make use of the speed limit of 90 miles per hour, I drive slowly, and I drive maximum 70 miles per hour. If this is his or her personal decision, I think because this is in line with his consciousness, I think this is fine. Second situation where I don't have a problem is if the legislator, there had been an informed public debate, and at the end of this debate the legislator had decided, because these environmental reasons, arguments are so convincing, let's reduce the speed limit to 70 miles per hour, after the parliament had decided on that. I think this is fine as well. The only problem I see, or the two problems I see, is if we have a speed limit of 90 miles per hour, and then the police is coming and stopping you when you're driving 70 miles per hour and telling you, well, that's not good for the environment, therefore I'm going to stop you now, and therefore you have to pay a fine. I think with such a situation I have a problem. And the second situation where I have a problem is if it's not the legislator deciding that the speed limit is reduced from 90 to 70, but it's somebody else. And I think this is also part of the debate, which goes to the roots of the democratic system, I think, that now we have the G20, we have the OECD, we have all kinds of international institutions and organizations, and sometimes not even international organizations, which are leading the debate and which are making the decisions. And the democratic legislator, the democratically elected legislator, is just implemented what had been provided by soft law. And I think this is the core of the issue, I think, those two problems I have. So coming, Mr. Chairman, to the issue of the GAARs, how is the issue connected to the GAAR problem? I think I realize that many countries have either now introduced GAARs or are considering introducing GAARs, and I'm not at all convinced if this is the right direction. Why? Because I think Jeffrey Owens a few minutes ago has made reference that we should not look only at the letters of the law, but also at the spirit of the law. And I think this is completely right. I completely agree with that. But I think this is nothing new under the sun. I think lawyers, educated lawyers, have done that for decades, for centuries even. And I think also in the tax environment, in the tax area, I think somebody, lawyer who was involved and who is involved in tax planning, well, if it's a good lawyer, then this lawyer has never looked only at the letters of the law, but also at the spirit of the law, and checked whether the structure he's proposing is in line with the spirit of the law. And I think that's the business, has always been the business of courts. And for an educated lawyer, and at least this is also what we are telling our students, the words, the letters of the law is just the beginning of the interpretation. It's never the end of the interpretation. You start with the letters of the law, but you have to take into account the context, you have to take into account the spirit, the intention of the legislator, and so on. Lots of the issues and lots of the arguments which had been mentioned by Jeffrey as well. I would just be careful with some others he has mentioned at the end of his short introduction, because I'm not so sure when we want to find out what the spirit of the law is, that this has something to do with the right ethical tax rate or whatever. So I think here we have to draw a sharp borderline. I think we should look at the subjective intention of the legislator at the time when the law was introduced. We should look at the context of the law and the whole purpose of the law. I think this is exactly what we have to do, but we have exactly to draw the borderline which values can we derive from the law and which are other values, very personal values, values which are prevailing in society. And this might make a big difference, and I think this is the big challenge also for tax administrators, but in particular also for courts, to draw the borderline between the values which can be derived from the law and which are the prevailing values in society, and this, or the personal values of the persons who are applying the law. And this is a big difference. And why are GAARs in that respect dangerous? Because I think they prevent us from being aware of that borderline. Because GAARs, usually, of course, GAARs might be drafted in different ways, but usually there is also a subjective element looking at the intention of the taxpayer, and at the end of the day, I think this is the entrance door for taking into account the values of the persons who are applying the law, either the government, the tax administrators, or the judges at the end of the day. And I think this is dangerous because this prevents us from distinguishing between the different values. And the second reason why I also think GAARs are quite dangerous for a legal culture is that I think at the end of the day, they are deteriorating the legal culture and the law as such. Why? Because, as I've said before, I think educated lawyers always have looked at the spirit of the law. And in order to cover situations which should be covered under the law, you have to look at the spirit of the law and the intention and the object and purpose. But once you have a GAAR, then you make it quite easy for tax administrators and sometimes even for judges in only to look at the spirit of the law in those exceptional situations where they think this situation should be covered. But in the regular situations, in the standard situations, they just look at the letters of the law. So therefore, I think we are back to the Stone Age to a certain extent, because in most legal cultures we have a development that we have been looking at the spirit of the law, and if we have GAARs, there is the danger that we forget about the spirit of the law and only look at the spirit of the law in very exceptional circumstances, very exceptional situations. So therefore I think it's bad for a legal culture to have GAARs. If we don't have GAARs, then tax administrators and judges are forced to look at the spirit of the law and find out what the spirit of the law really is, in order to see whether a certain situation is covered under the law or not. So therefore, for me, GAARs, that's not so much or not at all an issue of legal certainty, because I think it's an illusion that if we just look at the law as it is published, that we know immediately what the content of the law is. I think this is never the case, and this has never been the case. So therefore, in respect of legal certainty, I think GAARs don't make the difference. The law is to a certain extent uncertain, and we have to do research, and we have to look at judgments, we have to look at material, whatever, in order to find out, in particular for border situations, to find out where the borderline of the law is, where the scope of the law ends, and where it's beyond the scope, we have to look deeper. So it's not a question of certainty, but it's a question of in which situation do we take into account the spirit of the law. And again, I think this is the big risk. Once we have GAARs, once we introduce GAARs, then we tend to look at the spirit of the law only in very exceptional situations, and in all other situations we are back to the Stone Age and apply the law in a very primitive way.
Jeffrey, before you give a counter to Michael, I just wanted to have a view from Mr. Akhilesh Ranjan, because he in his capacity as competent authority is not in the middle of debating the GAAR legislation in our country, but also is India's spokesperson in the OECD, and what India expresses in the OECD BEPS project will be important. Mr. Ranjan, your comments?
Thank you, Mukesh. Some very compelling arguments made by Michael out here. Certainly very fresh way of thinking and looking at GAAR. And I think that is what is required. The debate must move away from these old arguments of certainty and predictability to what is the objective of GAAR. Can that objective be met otherwise? Why does GAAR really fit into a modern legal system? I think I'd just like to make a couple of points. One is that we have to look at GAAR in the proper perspective. Let us not. We have been talking about the last 1 hour of various debates between substance and form, of morality and immorality of the taxpayer or of the legislature. I think these questions are all now they arise from old and outdated concepts. They must not be thought of as relevant any longer. There are judgments which say that people must not pay more tax than what is required by law. I think that goes contrary to the present philosophy, where tax systems have to be based on voluntary compliance. So there is a clear contradiction. I think we are living in a time, in a place which is far removed from the context in which those judgments and those debates had arisen. So the point is that we have to look at the current perspective. Where are we now? We are at a place, at a very important crossroads in the history of taxation, where the world is realizing that the current rules do not work. The current rules are not capable of ensuring that every jurisdiction gets its fair share of taxes. They are not capable of ensuring that every business pays what it should be paying in the right place at the right time. There are movements, as Michael had mentioned, and there are movements by the G20. There is a base erosion and profit shifting, anti-base erosion and profit shifting project. There are various bodies going into these issues as to how to ensure that taxes are paid where value is created. And I think it is in this context we must now get away, as it was said in the McDowell judgment, we must get away from the ghost of Westminster. That was 1936, for heaven's sake. It's 80 years almost. I think we have moved on. The world has moved on. One has to now consider and accept the multilateral initiatives coming up at various levels in various fields, the cooperation, the need for cooperation, for exchange, which is recognized not just in taxation but in all economic activities. In this context of close interlinked nations and transactions, I think it is now pointless to say that, okay, go on to the debate of form and substance. Coming to the thing of GAAR, well, my personal view is that it's being looked at in a very incorrect perspective. Some people look at it as a magic wand which can get you the taxes that you can't get it otherwise, which is wrong. Some people look at it as a sledgehammer. Okay, this is what the tax department will hit you with if they can't get you with any other law. I think both perspectives are wrong. GAAR is nothing, it's just a law which is trying to prevent the abuse of existing laws. So it is trying to set right a system which is now trying to corrupt the legal system. And if the objective of GAAR is understood in that context, then all that remains is the care required to be taken in drafting that legislation, in implementing that legislation, and in ensuring administratively that GAAR is used in the right place at the right time and the right circumstances. So I think GAAR is very much relevant in the current scenario. I think we need to move away from the debate of 20 years ago. We need to look at what's going to happen in the next 10 years or 20 years. And if you look at that, we will clearly see that the current laws and the rules are not adequate. They have to be modified, they have to be changed, and in order to bring out the real intent of this change and this modification, a comprehensive set of GAAR rules has to be brought in and accepted as a requirement. Thank you. That's my view.
Thank you, Mr. Ranjan. Jeffrey, very quick comments before we move to the fourth module.
Yeah, very. My first point I'll make. I have a confession to make. You know, I'm not a lawyer. I'm just a simple economist. Yes, and that probably influences a little bit what I'm going to say. Speed limits. I think, Michael. You know, the attraction of speed limit. You're either over or under. Yeah. Tax legislation is by its very nature complex, and therefore it requires interpretation. Interpretation by the courts, interpretation by the tax administration, interpretation by the taxpayers themselves. On GAARs, you know, I'm getting tired of having a general discussion on GAARs because there are GAARs and GAARs. Yeah, you compare the original Indian proposals. Yes, that was a bad GAARs. Yeah, you then look at the UK one, very business-friendly GAARs. Yes. So, you know, you can't generalize. You have to ask what's the deal with the GAARs. Secondly, there's nothing new in GAARs. I mean, many countries have had substance over form rules, yes? So in a sense, it's just one step down the same road, yes? And the third thing, I think, and that's why I like GAARs, it helps you in the business community because it gives you a benchmark against which you can self-assess your tax planning. You can ask, will this get through or not, yeah? So that could actually lead to less disputes. But for GAARs to work effectively, I think three things have to happen. You have to have well-trained judges, yeah? You have to have a good, honest, non-corrupt tax administration, yeah? And you have to have good governance procedures. That's why the GAARs panel is so key for this, yes? Thank you.
Thank you. Yeah, please, sir.
I want to interject at this stage as far as the speed limit is concerned. First of all, there is emphasis by Michael on the spirit. But one thing we have experienced as far as Supreme Court is concerned is that our drafting in India is so poor that if you go by the spirit, you will land up in a confusion and there will be no clarity, there will be no certainty. And mind you, under the Indian Constitution, the essence of rule of law is certainty. The business must know where they stand for the future. So I would say that this spirit and all this discussion should be looked at from each country's point of view. Because what we are discussing is the context in which all these norms are operating. And let me say one thing. I am of the view that legality, as far as India is concerned, is the only test. Don't go by morality. Michael has referred to the speed limit. Now let me give you an example. What is the difference between a rule and a standard? Indian Constitution, Indian tax laws have to go by rules, by underlying principles. Now, not by standards necessarily. Let me give you an example. If the speed limit prescribed is 55 miles per hour, it's a rule. The man knows that this is the precise meaning. I have to drive at this speed. But if the norm says, you shall drive carefully, then all sorts of problems will arise because the man knows only possibly after the accident as to what you mean by saying drive carefully. That is the standard. Therefore, my emphasis is spirit is okay, but in Indian context, whether it is GAAR or any other legislation, it should be specific and it should be clear. Otherwise, we are going to face so much of litigation that it is not going to be a conclusive debate, and Supreme Court will have to face with reviews after review as to what the legislature really intended. This is the point, and I shall come to it when I speak a few words at the end.
Thank you. Thank you for your intervention, sir. We now move on to the fourth module, and I'd just like to quickly hand it over to my friend from Mauritius, Rajesh. Rajesh, there is a view being expressed that it is not just sufficient for companies, but it's important for advisors, and advisors play a very important role in meeting this test. What sort of substance tests are we talking about, particularly in the light of the debate that's going on between Mauritius and the Indian government on role of treaties. And where do you see this going? Because you've been a part of the working group as well.
Thank you. Thank you, Mukesh. I must say how privileged I am this morning to be amongst eminent speakers on this panel. Well, before going into addressing the questions you put to me, Mukesh, just one general comment on the topic we have this morning, which is, should international taxation be based on morality or legality? I think I would join here in the position of Chief Justice Kapadia there on the issue of morality. I mean, being a lawyer by training, I will have a problem with this issue of morality. I mean, that concept is so subjective that its length is going to vary with the length of the Chancellor's foot, as used to be the case centuries ago when equity was introduced in the UK. So we've got to be very careful with that concept and ask ourselves whether at this point in time this issue has come to the fore because of international economic global slowdown and the rest, and whether multinationals or companies are putting back enough into communities, into countries where they operate, and that is the real issue. And that takes me to a point which one of former legal philosophers raised, and that was Professor Lon Fuller, who was a chair at Harvard Law School, and when he spoke of the social role of the law as an instrument and the concept of the inner morality of a legal system. And he came up with a list of 8 desiderata which would have to be there for a legal system to have inner morality. And that binds with the issue which Arvind raised earlier about the issue of the morality of the legislature, because this is also the other side of a coin. And it connects well with the issue of whether laws have to be prospective, whether laws have to be made with clarity. And I can agree that one can have objections when laws are made with retrospective effect. But I would say that parliaments are sovereign, and it is sovereign for Parliament to make laws with retrospective effect. And in fact, under the Mauritian Constitution, there is a provision in the law that you can make law with retrospective effect. And there are a number of reasons you can do that, which can be purely technical reasons. For example, a law is being repealed, and you forgot, and the draftsman forgot to put a transitional savings provision in the new incoming legislation, and you end up with a gap in the law. So this is why Parliament is given this possibility to retroact laws so that you stick it with law that went away, so that there is no legal gap. But that is perfectly a technical solution, and it is perfectly legal. Now, the issue is what happens when Parliament legislates to cancel out the effect of a judgment. I mean, that is very questionable, because it raises very fundamental issues, and to me as a lawyer, it raises the fundamental question of separation of powers, which is fundamental to any democratic feature of constitutions, which India would have, which Mauritius would have, because separation of powers underpins the system of checks and balances. And that is something we have to look at. There is case law in Mauritius where the Supreme Court has struck down as unconstitutional laws which the executive very hurriedly passed to cancel the effect of a judgment which a person had obtained in his favor, and Parliament passed a law to cancel the effect of the judgment because it was an acquired right from that judgment. So that is an issue. Therefore, that would pose the question whether the legal system is stable or whether it in itself is a source of instability. And that is important for the investor, because the investor cannot one morning read in the press that something has changed and he has lost part of his property as a result of the law that has been changed while he was sleeping overnight and Parliament was sitting. And that is an issue. So does that pass the test of the morality of a legal system? Now, insofar as Mauritius is concerned, yes, there is the BEPS report which is out, and therefore we are at a time where it is a game change. But I would say, what you find in the BEPS is at times when you read properly the 15-point action plan, all wine in a new bottle. You would remember in the 90s, we had the harmful tax competition report, where in fact issues of substance had been raised, issues of transparency had been raised. And when we look at Action 5, it says revamp the work on harmful tax practices with priority on improving transparency, including spontaneous exchange on rulings related to preferential regimes. And we all know that when that came, the report of 1998 came, had a list of things there to be done. And of course, with time and international politics, the OECD sort of focused on other things. And now the question is refocusing.
We were encouraged by some of our bigger member countries to focus on other things, yes?
Well, that's putting it in the proper perspective there. But when you read the BEPS action plan, it talks about refocusing and revamping. And when you look closely, it's all wine in your bottle. Now, these have always been concerns of the OECD and other international institutions like UN, the issue of substance. Now, we're talking of a certain business model. As a game changer now, we have to look at whether this system doesn't work or has caused undue prejudices to some countries which have source-based jurisdiction. And the OECD in the BEPS report just also says, bring back source-based taxation. Therefore, talking about investment into India, I mean, at some point, Mauritius became important. India was an important partner of Mauritius, and the way of the traffic of investment at the time this treaty was made, I mean, has this changed? As I said the other day, if there is a treaty and there is an issue, the solution must be found through negotiation in the treaty. And this is the way you negotiate international instruments, which tax treaties are. Now, of course, there is the issue of substance that's based on the model where you have financial centers and so on. The question is, do you go for a financial center just for tax purposes? Or do you go for a financial center because there is a proper financial architecture that helps you, amongst other things, to mobilize capital quickly in short time, which would not be available in the country where the investment is going to take place? I mean, these are issues which tax planners or planners, advisors, financial advisors take into consideration, just not only taxation. I mean, it's part of it, but it's not the whole story there. Well, talking about GAAR, I must say that Mauritius has a GAAR since 1974. And the income tax of Mauritius was drafted by a New Zealander, and in the New Zealand Income Tax Act, you had a GAAR there. And this is where we got our GAAR. And that GAAR has been used for the last 40 years only 4 times. And the point I want to make is one doesn't use a GAAR every now and then. It has to be used very sparingly. And there are 4 cases, and in the 4 cases, 2 cases, the revenue lost. 1 case I appeared myself where the revenue lost. There is 1 case which is pending and the jury is out, which I've argued myself. So it's not easy for revenue to win a case on a GAAR, because bear in mind that the onus of proof is on the revenue. The initial onus of proof is on revenue. And it is very difficult because you have to understand the nitty-gritty of the commerciality of the business, because the taxpayer is going to come with hordes of advisors and planners as witnesses, and you will have to cross-examine them to show that, no, this is not the commercial reason, that was for the tax reason, and that is not an easy thing to do. So these are things I'd like to point out at this point in time.
Thank you. Just to close this debate before I hand it over to Justice Kapadia to wind up the session, I need a quick comment from Mr. Ranjan on role of tax information agreements, how this fits into the debate. To your point on retrospective applicability, this is a point I forgot to make yesterday. UK has grandfathered all structures up to 2013 before introducing GAAR. whereas India has selectively grandfathered. And I'll explain to you, the draft legislation says investments made up to August 2010. This is only investments, which means UK is talking about structures, so all kinds of issues would be covered, characterization, capital gains. India covers only investments. In other words, this seems to suggest to me that though the law is not retrospective, the structures would be retrospective, could be looked into. So Mr. Ranjan may wish to comment on that, but I certainly want him to talk about the role of tax information agreements in this debate.
Thank you, Mukesh. Yes, just before I speak on the information exchange, just like to say that I'm not fully in agreement with Mr. Ramloll's view that the BEPS project is an old wine in new bottles. I think there's much more to the BEPS project than a continuing debate on harmful tax practices, which is probably what is bothering Mauritius. There are many other initiatives, new concepts, new challenges that the tax world and the administrations are facing, which are being addressed. Things like definitions of intangibles, the evaluations of intangibles, the artificial structures for avoidance of the PE status. There are many things which I think had not been thought of earlier, which are now being addressed. So I would not agree with the statement that it is merely old wine in a new bottle. I think it's a very encouraging and very positive sign that there is an active debate going on the world over on these issues, and the G20 has taken a lead in that. So we should, I think, really be optimistic and hope for the best on these. One part of this BEPS initiative, or an allied part of it, is the need for complete transparency and an effective information exchange mechanism. Transparency is the order of the day. I think it's very clear internationally that the era of bank secrecy is over. It is now incumbent, and it is what every country would need, is to have as much of information as possible, and every country once then correspondingly is obliged to have its own system structured in such a way that there is transparency, that it is able to provide this information to the world community at large. So there is now a decision to introduce an automatic exchange of information system, which will be a multilateral system on a completely reciprocal basis, where every country would be required to set up mechanisms and systems which can have due diligence procedures incorporated, which can then provide relevant information automatically to other countries, which can, in a manner that can be used by those other countries, and similarly receive information from other countries. So that's a sort of an information explosion that we might be able to have to see in the next couple of years. And that is what I take it back to my earlier remarks, that the world order is changing. We are living in different times now. We are living in a place where there is so much of need of cooperation amongst nations. There has to be a different way of looking at things, of taxation, of allocation of taxation rights. They're all linked to these overall concepts of multilateralism. So the automatic exchange information project is something which I don't think any country in the world has yet said that they would not go for it. So it's something which has to come in the near future meaning a couple of years. It requires a lot of work. There are other initiatives which have preceded that, the FATCA legislation of the United States, but which I think would sort of become largely redundant once the automatic exchange system comes in. But FATCA is something that the world is facing right away. In June 2014, after the legislation will take effect if countries and institutions don't enter into agreements with the United States on providing the desired information. So if that sort of a law is accepted by a world community, by the United States just saying that I don't care, we won't give you information, but you give us every information about US citizens, and if you don't, I'll levy a 30% withholding tax on all payments to your institutions. It's bare, absolutely arm twisting, which is, but it's acceptable because that is the order of the day. Information exchange is a norm, a standard which is accepted. So therefore, there is no country can say that providing information is not the desired objective. Every country must offer and cooperate fully in these efforts to provide information. So, so things really have changed, and in this new age of information exchange, we hope to come to a juncture where there is complete transparency, which will also resolve so many other problems of abuse, of maybe treaty abuse. We really appreciate the efforts put in by Mauritius, for example, to provide a lot of information. They have been very, very cooperative. Wherever we have asked for information, it has been forthcoming. And once the automatic system comes in, and I'm sure Mauritius will not be far behind in that. So we are looking at a very positive note at things to come in this new world order, where there will be complete transparency, where there will be a minimum possibility of tax laws being abused, and where tax laws have been modified in such a way that more equitable distribution of revenue is ensured. Yeah, thank you.
Thank you. May I invite Justice Kapadia to come and deliver his welcome address. But before I do that, sir, I'd just like to add that though it's been 15 months that you have retired, we still miss you in courtroom 1. May we have the privilege of rising up as we rise in the court and welcome you with a standing ovation, sir. Please join me.
Good morning, everybody. It's nice to be amongst you once again. In last 1 year, I have been missing all of you. I am no more in courtroom number 1, and sometimes the memories do come back. But I am glad that in such seminars, I get an opportunity to share my experience, not only with the Indian audience, but even eminent people coming from abroad like Jeffrey and Michael. And I am deeply obliged for giving me this opportunity. All the panelists today are experts in their respective subjects, and the subject today is a bit contextual, and I would request all of you to consider whatever I say in the Indian context, because to my mind, relativity is what is important today. Even truth is not absolute. And therefore, it is better that we discuss the Indian conditions today. And my speech today is confined to the subject of morality and legality purely in the Indian context and in the context of how judges, including members of the tribunal, should approach subjects like transfer pricing. Now, friends, before I go to the taxation part of it, today, even under the Indian Constitution, it's very healthy to have confrontation between judiciary and the executive or the legislature. Not in the pejorative sense, but one thing we must all keep in mind is that today in India, what we need is to reduce discretion, because as Lord Bingham said, law is not discretion. So whatever laws you make, apart from drafting being drafting has to be good, but apart from that, we need to focus on concepts which reduces the discretion. Discretion not only of the department, of the officers, but even of the courts. And that is where I believe that morality is one subject which is a matter of approach, and it cannot be converted into legality. But here I would like to emphasize that whenever you talk about morality in a tax subject, I am of the view, and you may not agree with me, that in the Indian context, the discernible principles of law should prevail and not morality in the general sense. On the other hand, you have tax bearer bond case, where the Supreme Court has gone into morality, but that was a constitutional matter of validity of the bearer bonds case. So every law has to be interpreted in a particular context. Rule of interpretation which applies to constitution need not apply to taxation, because in taxation, like IPC or penal laws, you are imposing a charge. Whereas constitution, you can interpret the concept in the widest possible term and include morality. Therefore, please look at this subject purely from the Indian context point of view, and that is where I would like to say that morality is an approach. It cannot be converted into principles, otherwise you are tracing a pattern in shifting sand. The strength of the Indian judiciary, when I say judiciary, including the tribunals, the income tax appellate tribunals, I am of the view, as Justice Matthew has said, that the strength of the Indian judiciary is on case-to-case adjudication. Please don't lay down an across-the-board principle. Every principle which you lay down should be confined and understood in the facts of the case. Therefore, according to me, morality and fairness is a goal. The methods by which you arrive at that goal may differ, and that is where legality comes in. One thing we must remember, that subjects are not taxable according to the spirit of the statute, but only by the plain words mentioned therein. This is the rule of interpretation which has been followed not only in tax matters, but even in all matters. Morality is not capable of a precise definition. It is a variable quality. Morality as perceived by the SSE is different from the morality as perceived by the department. Friends, it is said that even when it comes to constitutional matters, sometimes the executive criticizes the judiciary for its overreach. Why this criticism is there? It is because the morality of courts is different from the morality of the government. The morality of courts is based on principle of reasonableness. The morality of the government could be on the basis of vote catching, politics, and other consideration, including achievement of revenue targets. I am going to come to that subject later on, because to my mind, that is what needs to be looked into. Therefore, morality goes with the values. Morality differs from country to country. It differs from age to age. And therefore, what morality enjoys is what is ultimately conducive to our interest. Friends, let it be multinationals, let it be an ordinary human being. Ultimately, the person will go by his own individual self-interest. And let us be very clear, as far as India is concerned, brand India represents less cost. And that is why you have profit shifting. You have transfer pricing norms, because brand India represents less cost. Cost arbitrage is one of the aspects. Now, whether you call that as immoral, whether you call that as within the legal parameters, is a pure subjective matter. Is it a bad morality? And I ask a question, is it a bad morality? Under Indian conditions, for anybody to arrange his affairs so as to reduce the brunt of taxation to a minimum. If I have to reduce my tax liability, is it immoral? This is the question. If it is immoral, then of course morality has to be the benchmark. But if it is within my legal right, under the tax law or the law which makes a provision for that, can you say that such an approach is immoral? Or will you go and judge such an approach by the test of morality? My answer is we have to go by pure legal principles as enshrined in the Act, and please don't go by overarching principles. Overarching principles comes in when the legislation is poorly drafted, when the courts do not know how to judge a particular device. That is where overarching principles would come in. But the primary importance the court has to give is to the text of the Act. This is what I am looking at, and this is how the courts in India will look at. And therefore, the basic point is go by the underlying discernible principles and not by overarching principles or such variable subjective concepts. This is what I intend to say. Further, now this is very important. We have been citing McDowell's judgment repeatedly, and this is what I want to emphasize at this stage. See, if morality is the requirement, then see how the approach differs and see the consequence of the litigation which will increase. In this connection, very often the judgment of the Supreme Court in McDowell is cited by the department, in which the Supreme Court has noticed the change in the judicial attitude to tax avoidance devices. Justice Chinnappa Reddy said that even in the country of its birth, the Westminster principle of condoning tax avoidance has been given a decent burial. Relying on the said objects and the observations in the Supreme Court, in another case of Commissioner of Wealth Tax versus Arvind Narottam, the learned department lawyer submitted that having regard to the taxing statute, the court should now construe all the transactions by seeing the game of the hidden purpose behind the documents. This was the argument relying upon McDowell. This is what the answer is given by another eminent judge, Justice Sabyasachi Mukherjee, later on. And this is what is stated, because we are looking at McDowell without looking at the subsequent judgments of the Supreme Court. And this is what the Supreme Court has said, and this is what I would like to quote. It is true that tax avoidance in an underdeveloped economy should not be encouraged on the practical and ideological grounds. Morality is an ideological ground. One would wish, as noted by Chinnappa Reddy J., that one could get the enthusiasm of Justice Holmes, who said that taxes are the price of civilization, and one would like to pay the price to buy the civilization. Now this is where Justice Sabyasachi Mukherjee differs, and he says, but however, in the Indian context, the question which may ordinary taxpayer would ask is, in a country of wasteful expenditure, are we paying the tax as a price to buy civilization, or are we facilitating the waste? Please answer this question. And this is where Justice Sabyasachi Mukherjee further says that unless waste in government spending is avoided, no amount of morality or moral sermons will change the approach of the people towards tax avoidance. Now, I am not saying that wasteful expenditure means we should not pay tax. What I am trying to say is that in our country, if morality is going to be the principle, then views are going to differ. And that can never be the approach of the courts or the tribunal. Because as I said, even the morality of the government will differ from the morality of an assessee or a taxpayer. And the only solution to this conflict is between a functional approach and a normative approach. To my mind, morality will come under normative approach. And unless the concepts are well defined, as I said, difference between rule and standard, unless the concepts are well defined, we will not be able to solve the problem between morality if we go by morality. Therefore, see further. What is the problem as far as Indian legislation is concerned? And I fully agree with Mr. Datar. If one goes by morality or fairness, then one has to keep in mind that motives have no place in jurisdictions. Now let me pause here for a minute. Under the Indian Constitution, we have social justice, which assumes that all people are equal. But that is a fallacy. People are equal only in the grave. That is why our constitution framers have not used the word equality per se. I am informing you because unfortunately in India people are not reading the constitution, which is so well drafted. Our constitution uses the word equality of opportunity, not equality per se. This was carefully drafted. Secondly, why has the Indian constitution been so exhaustive? Because the constitution framers knew that problems of corruption, wasteful expenditure would be there, and we need to control it by a detailed constitution so that the discretion is reduced. And discretion of the courts is also reduced. Therefore, the importance is to the text. What I am appealing to Akhilesh is, you may draft GAAR, but please don't draft laws only to achieve revenue targets, because that is an approach, that is not a principle. And this approach, I am not blaming the tax officers. If you set the revenue target so high, the tax officer is not going to apply arm's length principle. I have seen so many tax judgments written beautifully by the tribunal, and from the facts, particularly in transfer pricing, from the facts, what do I see? Even if the SSC makes out a good case on arm's length pricing by referring to segment margin, when it suits the officer, because of the pressure of revenue requirement, he will say, I will go by entity margin. And when in a given case, exactly opposite, where the ALP or the arm's length price is based on segment entity margin, the officer will say, I will go not by entity margin, but segment margin. Now, this approach is based on requirement, revenue requirement by 31st. That is not principle, that is an approach. Therefore, if you go by the strict principles of ALP, if you go by the principles which are underlying the tax law, then this problem can be solved, and we need not debate on morality as far as India is concerned, on morality or legality. You strictly go by the principles. The courts will also go by the principles. Why are we emphasizing the principles? Because principles land objectivity. It lands certainty. But the officer is faced with so much of burden that he will go only to the revenue requirement. So whichever law you may make, as long as this mindset works, as long as this approach remains, all this discussion is futile. How to get over it? Follow the principles. And therefore, friends, in conclusion, I would like to say one more aspect. In the media today, we see different opinions. More than news, it is opinions. What is the reason? Sometimes courts are criticized also as far as their judgments are concerned. Sometimes, many times without reading the judgments. The reason is this: love for justice is very rare. Most people desire injustice which favors them. This is the problem. We want justice as we like it. We want justice as we favor it. So in conclusion, friends, please don't go into this dichotomy of morality and illegality and legality, form, substance. Go by the text. And in conclusion, I would like to say that what is ultimately necessary for the courts and the tribunal is to remember one principle. Let us worship at the altar of underlying discernible legal principles and not approaches. Thank you.